Second case on this morning's docket, case number 118237, State of Kansas v. Erica Tatro.
Joel Enzi, may it please the court. Joel Enzi representing the petitioner and defendant, Erica Tatro. And may I please reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. So today I'd like to talk first about a little bit about the facts of the case and how we got here, and then transition into the attenuation analysis and focusing primarily on the third prong of the attenuation analysis, the egregious police misconduct. So a little bit about the facts. Ms. Angela Tatro was seen walking alone at night on a very dark portion of the street, down the middle of the street with an illumination device of some sort of or light. The officer sees her, pulls around the block, pulls up next to her, asks her to stop, shines his alley light on her, what's like a spotlight, gets out of his vehicle and asks her to stand over by the curb. And that's when he tells her the reason for his stop. To paraphrase, his reason for the stop was that it's late and people get into situations where vehicle burglaries take place, and we have to ID people to see what they're up to. And that's what he proceeds to do, is identifies her name, date of birth, where she lives, where she works, who are the people that she lives with, some general information regarding her. He then tells her that this isn't your first time with interaction with law enforcement, is it? She says no. He tells her something to the effect of, hold on tight while I go and run your information to make sure everything checks out. Everything does not check out. She has a warrant for a failure to appear, and she is arrested based on that warrant. Search incident to the arrest and finds methamphetamine and paraphernalia. I filed a motion to suppress. At the motion to suppress hearing, the officer testified that the reason for the stop was there was a report of windows being shot out 3.5 to 4 hours earlier. The fact that she was walking down the middle of the road caught his attention with a light that was indicative to him of someone trying to or about to commit vehicle burglaries, and he stated that that was based on his training and experience. However, didn't really articulate what about his training and experience caused him to be suspicious, that was suspicious behavior. The court, after hearing the testimony, suppressed the evidence, citing that it was egregious police misconduct and that the only way to deter future random stops of citizens was to suppress the evidence. The state appealed. The appellate court overturned the district court. In citing, in their opinion, they stated that it was legally indistinguishable from the facts of Utah v. Strieff. However, they appeared to be using some facts that were not in evidence at the suppression hearing. Stated that the officer, when they were doing their analysis of the reasonable suspicion, whether the officer had reasonable suspicion, stated that the officer was on heightened vigilance because of the reports of vehicle burglaries that were earlier, as well as the reasons previously stated. And they stated that that was not enough to rise to reasonable suspicion. Later, when they were discussing the attenuation analysis, they once again said it was not able to distinguish between the Tatro case and Utah v. Strieff, citing that both officers possessed a subjective belief into reasonable suspicion to conduct that investigation. And so coming back to Strieff and discussing the 3 prongs of the attenuation analysis, the temporal proximity, the presence of intervening circumstances, and then whether there was egregious police misconduct. The court's analysis in Strieff regarding the third prong, the egregious police misconduct, they stated that this...
Before you get to that,
Sorry, yes.
Can I focus this on the second prong? What do we do with the fact that the district judge just said, I don't find an intervening cause? Is there any way to read Streiff without saying that the warrant is an intervening cause? It's just a question of whether the other factors that might outweigh that?
And I don't know what the district court meant by saying that there wasn't an intervening factor. I don't know if it was saying that the intervening factor was not sufficient to purge that egregious police misconduct. But I'm not for sure. I think you can read it that way, that this intervening factor was not sufficient to purge that conduct.
How do we do that under our standard of review? Because Streiff separates the analysis into three. The flagrancy is a separate step of the analysis. So do we just have to accept that there might have been an error of law on step 2, but find that that's harmless because of the egregious nature, or the finding that it was egregious, or how do we structure our analysis of what the trial court did here on that issue, on that factor?
I believe the standard of review is, based on substantial competent evidence, and then reviewing the legal conclusions de novo.
So would we say that there was not substantial competent evidence to support the conclusion of law that there was no intervening cause? Is this really a conclusion of law that a warrant is an intervening cause, isn't it?
I think that it is.
So there was error there, but you're saying despite that error, we can affirm because we should uphold the district court's implied decision that the egregiousness outweighed? Is that what you're saying?
And I think this court can review the determination of that it wasn't an intervening circumstance, and then there was testimony that there was obviously a warrant, that she was arrested on this warrant. But then using also her further analysis that goes into the egregious police misconduct, and that outweighs the discovery of the pre-existing warrant.
Just so we're clear here, you're conceding that the existence of an arrest warrant is, as a matter of law, an intervening circumstance within the Brown or Streiff analysis.
In my brief, I say that this court obviously does not have to follow the U.S. Supreme Court, but based on jurisprudence, this court has always interpreted our Constitution to be in line with the Fourth Amendment. I would say I'm not conceding that point, but based on prior jurisprudence, the stronger argument is that was egregious police misconduct overrides the discovery of the pre-existing warrant. And I think that is also supported by Streiff's analysis of what is egregious police misconduct.
Can I parse that a little bit to see if I understand what your answer was to Justice Johnson's question? So you were saying that under 14th Amendment law, we have to say it was an intervening cause, but perhaps we can, under Kansas Constitution, take a different track. Is that what you're saying?
I think I cited in my brief that this court can provide more protection to its citizens. I am saying that. I don't know if that answers.
Let me just break it down. Are you saying that under the 14th Amendment it is an intervening cause?
Based on this court's prior case law, it is an intervening cause. Just how much weight is given to that warrant. Prior cases in Williams and Morales said that it was an intervening cause, but just didn't provide as much weight as what Utah v. Streiff gave the discovery of that existing warrant.
And I think in Williams we were very purposeful in saying that the Kansas Constitution provides at least as the same level of protection as the 14th Amendment, indicating that we could say that it was different.
Correct. So moving on to Streiff and what they describing as egregious police misconduct. I think in Streiff they described what wasn't egregious police misconduct. And when something is purposeful or flagrant on behalf of law enforcement. We decided something is egregious police misconduct. They stated that what the officer did in Streiff was not purposeful or flagrant. He was involved he received an anonymous tip that there was drug activity in a house, conducted a week-long investigation, observed frequent short-term guests that would heighten his reasonable suspicion into what was going on into that house. However, Streiff was a visitor there, left, and he made a stop of Streiff, and then discovered a warrant and was arrested based on that warrant. The court described the mistakes that he made in Streiff as good faith mistakes. And his first mistake was not knowing whether Streiff was a short-term visitor, and then that he should have instead tried to make a consensual encounter as opposed to a Terry stop. And they went further, not that he only needed to make good faith mistakes, but those good faith mistakes were an isolated incident of negligence in connection with a bona fide investigation. And I think that's an important distinction to make when we're reviewing Streiff compared to our current case in Tatro. Court in Streiff also talked about what a fishing expedition, that a fishing expedition this court has talked about in Williams and Morales would at least rise to some level of egregious police misconduct. And the court...
Does Streiff change that though? And in particular, I'm thinking of the portion of the Streiff opinion where they respond to Streiff's arguments about why, about the flagrancy, and they say that Streiff is conflating the issue of the lack of reasonable suspicion with flagrancy. And is that what Williams and Morales do as well? Is basically say that if you have a fishing expedition or a hunch, that's not enough, you don't have reasonable suspicion, but you can't conflate that with flagrancy?
If I understand your question right, saying that if Streiff no longer is saying that a fishing expedition would rise to the level of egregious police misconduct.
Let me just read the two sentences that I focus on and from Streiff. Streiff argues, moreover, that Officer Fackrell's conduct was flagrant because he detained Streiff without the necessary level of cause, here reasonable suspicion. But that conflates the standard for an illegal stop with the standard for flagrancy. For the violation to be flagrant, more severe misconduct is required than the mere absence of proper cause for seizure.
Correct, and I think they then discussed, I think when they were discussing the fishing expedition, I don't remember if it was right before or right after the sentences that you were quoting, and they went back and said that this wasn't a fishing expedition in search of just in the hopes of something that would turn up, and they cited back to his bona fide investigation of what he did while he was conducting his investigation, and that Streiff was associated with that investigation coming out of the house that he legitimately suspected of being involved in drug activity. So I don't think that Streiff is saying that fishing expeditions are no longer can rise to the level of flagrancy or purposeful and then amounting to egregious police misconduct. I don't think Streiff changed that analysis.
Tell me what was, if you would list what was egregious in this case.
In Tatro?
Yeah, in Tatro.
Tatro, I think it was a fishing expedition based on what the officer told her was the reason for the stop. It's late. People get into situations where vehicle burglaries take place, and we have to ID people to see what they're up to. So that's what he was doing. He was identifying her to see what she was up to in the hopes that something would turn up, and that's a fishing expedition. There was no current investigation into ongoing criminal activity. The only call that the officer had was a call 3.5 to 4 hours earlier about windows being shot out.
What I heard you arguing is more of a good faith, that you were saying the distinction in Streiff was the officer had good faith, albeit not legal, reasonable suspicion, and you're saying here that a officer that should know that they don't have the right is not acting in good faith? Is that what you're trying to say? The distinction here on egregious, it has to do with the good faith or bad faith of the officer? Or?
That is what I'm saying. That the officer in Streiff was acting in good faith while he was conducting an ongoing investigation into this house. There were no really good faith mistakes that were made when he stopped Miss Tatro. She wasn't a suspect that had been identified as leaving the scene of this crime. He didn't think that she had been involved in any recent vehicle burglaries. So there was really no good faith mistake to have been made when he stopped her. He just stopped her in the hopes that something was going to turn up.
So is the difference not the absence of reasonable suspicion? Because the mere absence of reasonable suspicion only gets you past factor number one. But it's the knowing you don't have it when you stop them. That's what makes it not a good faith situation. Is that what you're trying to say? An officer can make a mistake about
Right.
whether he or she has reasonable suspicion to make a stop, right? They can make a mistake.
Correct.
And that would be acting in good faith if they make a mistake.
Correct.
But you're
Correct.
saying, no, this is different because the officer knew he lacked reasonable suspicion when he made the stop. He was stopping only to get an ID that he could run.
Correct. Correct. That is what I'm saying.
Okay.
And isn't that kind of what the district court found?
Yeah,
That the officer really didn't have an honest belief that he had a legal basis to make the stop.
I think that
That's
is
kind
what
of what the district court found.
I think that is what the district court found. Here's
Have
another.
any further questions? Thank you, counsel.
Thank you.
May it please the court, I'm Brock Abbey, an assistant Saline County attorney, appearing on behalf of the state of Kansas. First, the state conceded the first factor, the first Brown factor, because as you all probably know very well, the stop of Ms. Tatro by Officer Garcia and the discovery of the warrant was very quick, within minutes. Not what I think they said in Streiff, a substantial amount of time that might favor the state. So we conceded that issue, but argued the second and third factors favor the state and reversing the suppression order. First, the Court of Appeals said this is legally indistinguishable from Streiff, and I think it kind of goes to that second prong, the warrant being discovered as the intervening circumstance. I think we have to remember when Streiff, what it was designed to do, right in their preamble before they get into their legal analysis, they're talking about the Green case from the Seventh Circuit and Morales from this court, where they were actually going to decide the split between the Seventh Circuit that says that discovery of the warrant is the end all. Once they discover the warrant, there's no other question, and then where they cited Morales in this court saying that that actually has very little weight. They were going to solve that, I guess, sort of split in the lower courts. And it seemed to me that the Supreme Court in Streiff, when they did that, kind of favored the Seventh Circuit approach and put a lot more weight on the intervening circumstance of the warrant being found. Obviously, they kept the three factors from Brown. But in this case, we believe that the testimony and the evidence was the same, basically in Streiff, that here we're on appeal in the position that we have to assume that this was an unconstitutional stop, that it was an illegal detention, much like Streiff. The state conceded in that case. And then we proceed to determine whether that warrant sufficiently attenuates the unconstitutional stop. And one of the major things the majority focused on was the fact that this warrant is a judicial mandate, that at that point, Officer Garcia in this case had no choice but to arrest Miss Tatro. Disregarding the illegal conduct that was found later, he at that point had no choice but to arrest her, and then obviously was allowed to search her incident to arrest under that categorical exception to search.
Doesn't Streif have a fail-safe, though, for egregious conduct?
It does, the third factor, Your Honor, and I know Judge Young in the district court found, I think, I don't know if we're kind of interchanging using the words. I know my friend Mr. Enzi's used egregious. Streif uses the word flagrant.
Okay, I'll go with that.
Sure. And so I know Judge Young found that in this case, that the stop of Miss Tatro was this either flagrant or egregious police misconduct. And my response was, where you went with that, Justice Lukert, is the Streif opinion saying that without more, that's not necessarily flagrancy, just the lack of reasonable cause or reasonable suspicion. And I think that that's...
So what was the testimony about what he believed when he stopped her?
Going back, I think, and relying on his training experience, he started with how many years he's been an officer, how many years he's worked this beat, how frequently vehicle burglaries occur, almost daily or every other day.
So
And-
did he believe it was the law that he could stop anyone as long as it was the middle of the night?
It appeared to me his belief was more akin to that this was a Terry stop, what we would consider a
I
Terry stop.
understand that he says that that's the legal position of the state. But what was the content of his reasonable suspicion? What did he have? What information did he have?
I think first his experience and how frequently these occur, and then just hours earlier in the same evening, night, I think this is early morning hours, so probably late PM hours, early morning, that these incidences had occurred in the area.
The windows being shot out were supposed to be in cars?
Yes.
Okay.
And I think,
But didn't he also say he only saw her shine her flashlight to, he didn't see her looking at into cars. She was actually walking down the street where she was away from cars.
walking down the Miller Street, illuminating, I believe is, and I think you're right, I think the testimony was that Officer Garcia didn't see her try to illuminate any sort of cars that were along
So
the
there was
street.
nothing about her behavior that he identified was there, other than it was
Well-
late at night and she was walking.
I think, although he didn't see her shining lights into cars, he still thought it was suspicious that at that time, in that location, with those prior calls in the evening, that somebody walking down the street was a flashlight that could be doing those sorts of things, engaging in that illegal behavior that he was suspicious of.
Wasn't there testimony that he wasn't even sure whether there were cars on the street where she was walking?
I don't know, I can't answer that
Okay,
for sure.
we can
Your Honor.
just
I
look at
don't-
the
I just-
record on that.
Sure, the transcript would show, I just don't recall.
Was there any evidence in the record that the officer held a subjective belief that the stop was not lawful?
No, and that kind of gets me to another point on the flagrancy. In Streif, they kind of talk about, is this a pattern of police misconduct? It's something that, either Officer Garcia, there was no evidence in the record that he's done this before, or, a judge in a previous case had found that he couldn't do this or anything like that. Or moreover, even, I suppose, the Salina Police Department, there was no evidence that this is a policy or practice of the Salina Police Department to walk or stop everyone walking down the middle of the street at night with the light, anything like that, that I think would, if you had that maybe in the right case, would add to whether this was flagrant because it's an ongoing recurring issue rather than...
What we do have is the words of the district court that said the reason for the stop by Officer Garcia demonstrates egregious police conduct, end quote, and then goes on to say the suppression would, quote, serve the purpose of deterring law enforcement from randomly stopping citizens without reasonable suspicion, end quote. So at least we know the judge is saying things that could support the finding of flagrant or whatever. You're saying that the evidence didn't support that finding. Is that what you're saying?
Yes, Your Honor, and I think going back to Justice Byers' question to my friend, I think that that's right, that it would be a lack of substantial competent evidence to support that conclusion. And I would revert back then to Justice Lukert's question and the Streif opinion saying that without more, just the lack of reasonable cause to stop somebody isn't necessarily flagrant. And I think that's exactly what happened here, and I think that's why the Court of Appeal said it's legally indistinguishable. Upon review, it was determined that it wasn't a consensual encounter, it wasn't a Terry stop, and
Would you agree that if the record demonstrated that an officer had a subjective belief that a stop was not justified, but made the stop anyway, would that qualify as flagrant or egregious?
I hate to speak categorically. I don't think just categorically it would automatically. I know that's
What
different.
what would it take? I'm real curious about the practicalities here.
Sure.
If your opponent in one of these cases wanted to bring in other folks who'd been stopped by the same officer, completely unrelated matters, not this one, but wanted to bring those folks into the suppression hearing to demonstrate that this officer made a habit of just stopping people and asking for ID.
Could you do that? Is that what you're saying?
Yeah, would you say irrelevant?
No, I would say that goes into whether it is flagrant and that continuing ongoing pattern that they've described that may add that more severe police conduct to make it a flagrant finding. I just don't think we have that here.
Okay, well, we obviously don't have it here. But short of that, if the officer testified, I knew I didn't have reasonable suspicion, but I stopped her anyway, that wouldn't be enough for flagrant conduct?
Like I said, I hate to say a categorical yes without...
It's not categorical. We're suggesting and hypothetical. The officer testifies. When I stopped this individual, I knew I did not have reasonable suspicion.
I think my answer would have to be no, then it's not flagrant just based on that. If you're considering only whether the lack of reasonable cause equals flagrancy, no, I think that they said that in the street.
No, it's more than that. It's subjective knowledge of the lack. It's not an honest mistake. I didn't make an honest mistake. I knew I didn't have reasonable suspicion. I stopped her anyway.
I guess I still don't see that as flagrant or egregious misconduct. No.
Let's move that hypothetical to other language in Brown Factor 3, which says the purpose of the official misconduct. The whole thing reads the purpose and flagrancy of official misconduct. Let's just emphasize purpose. If the officer said, basically, my purpose was to stop this person, even though I knew I had no reasonable suspicion, doesn't that meet that element?
I think it adds more towards the flagrancy element. I don't know that in and of itself alone it qualifies. Just stopping somebody on the street.
Who says, I knew I had no reasonable suspicion, but my purpose was to stop them and run checks on them. Isn't that part of the Brown Factor number 3?
Yeah.
Isn't that official misconduct?
Sure, and if maybe I'm misunderstanding you, but you're...
Forget about flagrancy.
Okay.
And just say, on this one occasion, the officer said, my purpose in stopping this person is because I wanted to run a check on them and find out if there were any outstanding warrants. I had no reasonable suspicion. They were minding their own business. Would that therefore not constitute purpose of his official misconduct?
Yes, I think,
Okay.
and maybe we're losing ourselves. I was trying to distinguish that between an officer who thought they had at least they thought it was a consensual encounter versus knowingly going into it with a bad motive, I guess, an evil intent, something like that.
And I don't want you to seize on the part of Streiff that I read to indicate that it's as clear as what you are arguing. Because as your opponent indicated in the sentence just before that, they discussed whether or not this was a fishing expedition and said, this was not a fishing expedition, and they cited their case law prohibiting fishing expeditions, the Taylor case and others. So I just don't think Streiff is very clear. I don't think the court was very clear about where's the line here. Is there a line between the difference between a fishing expedition and just a technical lack of reasonable suspicion, if you would? And so do you have thoughts about that and how to interpret that part of their opinion?
I think if you look just at the last part of the opinion before the sentence start, the majority kind of discusses that sort of parade of horribles that might occur should law enforcement start abusing this sort of thing. And the majority says, this is just what happens in this balancing of the factors. If the facts were different, if the evidence came in at a hearing differently, then that might weigh in favor of suppression. So if you start adding more flagrant violations or something like that, and I was trying to think of, what's more flagrant, what would be an example last night. Instead of just stopping Miss Tatro and asking her to move to the curb and talk to him because it's out of the traffic way or something like that. If he had physical contact with her, restrained her, something like that, might be more flagrant and tip the scales the other way. I just, for my purposes, I don't see it distinguishable from Streiff in that Ms. Tatro was stopped on the side of the road, so was Mr. Streiff. In both positions now, we're in a position where neither officer had cause to do so. They eventually run the identification and find the warrant. I think the Court of Appeals, in their opinion, also discussed how courteous Officer Garcia was in this case, not raising his voice, not really issuing commands of her. And so I think that reduces any sort of flagrancy at all, as well as...
Isn't there a part of this, though, that is credibility? Just looking at the trial court is sitting there seeing that officer testify, and the trial court, having heard that, says this is egregious. How do we not cross the line where we're reweighing credibility of evidence that was heard in the courtroom?
Because I think it goes back to more of your de novo review of the legal conclusion, assuming everything, obviously you don't have the credibility determination because you can't see the witnesses, but assume the facts are the way they are. Does that still support the legal conclusion? And that's what you can review de novo without any deference. Are the facts as they came in, would this support that finding that this is egregious, flagrant conduct?
If we find that the district court applied the wrong legal standard, would we have to remand for a do-over on the suppression hearing? Because I could see the scenario where the district court would actually make a finding, which I don't see in the record here. This officer's testimony is not credible. I make a factual finding that this officer knew he had no legal cause to make the stop, and I find that to be egregious.
Yeah, I don't think that finding that you've just announced is in
It's
the
not
record.
in the record.
Right.
My question is, if we agree with you that the district court applied the wrong legal standard, would we have to remand for a do-over? Or would we just affirm the...
I would welcome that if to present the evidence on that issue. I know Judge Young didn't say that one way or the
What's your
other.
reading of how the Court of Appeals handled that? Was that... Was their ruling that the evidence comes in and can't be suppressed, or...
It is that it's admissible
Okay.
and it's attenuated, essentially.
Right. That was my reading as well, so... But you're saying now, in response to my question, that you would welcome the opportunity for a do-over on the suppression hearing.
Well, only if you're only if you're going to reverse the Court of Appeals. I think the record supports that you can make the de novo determination that it
That
is...
would only be your fallback position.
Yeah.
Your primary argument is evidence comes in.
Yes.
Well, how
And
did
no
the-
deference to the district court's credibility determination.
On factual findings, obviously, I think you have to do that, but not the legal determination. Not the whether it's egregious or flagrant or anything like that. I don't think you have to.
What supports some of the conclusions the Court of Appeals draws, though? What supports their conclusion that Officer Garcia clearly believed he had reasonable suspicion to investigate a rash of vehicle burglaries, for example? And that's just one of several sentences that your opponent points to.
I think going back to what I originally said, working that beat for several years and how frequently it occurs, and that vandalism had occurred earlier in that night, that he was suspicious that this person out that late in that area in the middle of the street with a light might be engaging in the same behavior, that it was reasonable for him to believe that, I guess.
But that requires drawing several inferences from the evidence. There's no direct statement by the officer to that effect, is there?
I'd have to go back and look at the transcript.
Well,
transcript and my
even
record.
if there is a direct statement, there still has to be a credibility determination whether the court believes that statement, and why what I'm hearing my colleague asking is why wasn't the Court of Appeals making those factual findings that the district court didn't make?
I would hesitate to answer, Your Honor. I don't.
Well, it reads like they're making factual determinations that don't appear in Judge Young's
Findings.
findings, correct?
I think, yes, they're factual findings probably that aren't her findings, but there would be evidence of in the record, but yes. I see that amount of time. Is there any further questions?
I see none. Thank you, counsel.
Your Honor, we would ask you to affirm the Court of Appeals reversing the district court. Thank you.
I'm going back to a few of the facts discussed at the suppression hearing. The officer testified that vehicle burglaries take place, he said, daily, not every other day, weekly. So I think that all that we really know is that vehicle burglaries possibly take place at least weekly. And when he's talking about investigating criminal activity, I think we can see whether he was or was not investigating criminal activity based on the questions that he posed to Ms. Tatro that night. He didn't ask her about any questions of criminal activity. And the only call that he referenced at the suppression hearing was the criminal damage, the windows being shot out. He didn't ask her where she was at 11:30 or 12. He didn't ask her if she was around that area during that time, or no questions relating to any kind of criminal activity. Once again, just questions about her and seeing what she was doing. And I think the court because the officer testified that he was investigating her for either these burglaries or for the criminal damage. And on page 9 of the court's opinion, she states, as to the third factor, Officer Garcia did not stop the defendant because he suspected she had committed, was committing, or were about to commit a crime. He repeatedly testified he stopped her only for walking late at night in the street in an area known to have vehicle burglaries or property crimes. So he essentially stopped her because it was late at night in what he described as a high crime area. And what I would again submit that goes towards the fishing expedition that he was committing, or that he was performing on Ms. Tatro. Also relating to possible pattern or practice, once again we can look at what the words that he used, whether it was a pattern or practice of behavior. While we don't have any evidence to say that there's been multiple people that this has happened to, what he says is, we have to ID people, and I don't know if he says so we can see what, or so I can see, but I think he says we have to ID people so we can see what they're up to. I think that gives a little bit of light into what's in his mind as far as what he has to do, what his duties are, is to ID these people and see what they're up to performing a fishing expedition. And I think that goes towards the purposeful or willful conduct on behalf of the officer. If there's no more questions, I just simply ask that the court overturn the appellate court and uphold the district court's finding that this conduct was egregious police misconduct and suppressing the evidence. Thank you.
Thank you, counsel. We thank you both for your arguments this morning. The clerk will take this matter under advisement.